Okay, well, welcome everybody to the July edition of Sprintlaw's monthly webinars. And today we'll be talking about the Closing the Loopholes employment laws and how they might be affecting small businesses. Just a quick introduction to Sprintlaw for those who are not already members or know us already. We're an online law firm really designed for startups and small businesses. Unlike traditional lawyers, we don't charge by the hour. Everything we do is fixed fee. And we can help in most areas of business law, from setting up your business to IP protection, privacy, employment law, lease reviews, general commercial contracts, pretty much anything that you might need. We also have an optional membership, but about 90% of our clients sign up to it. And it's a really great sort of a way to engage with us on an ongoing basis, stay on top of all your legal requirements. We have a legal health monitor in there, e-signature tools, credits to use on legal services, and a ton of other things as well. And there's a free version of it for those that just want to have a poke around and check it out. So I suggest that you check it out if you haven't already. A little more about us. We've been around for about 8 years. We have a bit over 8,000 clients, won lots of industry awards, and we're in also expanded from Australia to the UK and New Zealand as well. So for those of you with an international angle to your business, we can often assist with that as well. And if you are interested in getting more help with employment-related legal services or assistance, we'll drop a link in the chat, or there's a QR code here as well for you to book in a free chat with our team. We can provide some guidance on some questions that you might have following from this webinar and some discounts on some services if you need them as well. So let's get into the content for today. We'll be talking mainly about the Closing the Loopholes laws, which were a pretty major set of reforms that were passed last year and have been coming into effect over the last 12 months. Most of them are now in effect. Some of them are coming into effect in the next few months, but they have a pretty major impact on the way that employment regulation works in Australia. And we'll be covering some of the things that particularly may affect small businesses. Many of them are not that relevant to smaller businesses, but there are a few changes that are definitely worth being aware of if you are employing staff. So the Closing the Loopholes laws were divided into two sections. So we'll go through what's the difference in terms of the two sections of laws that were passed. Then we'll be focusing firstly on the changes that were made to the way that casual employment works. We'll be going through the right to disconnect, which people may recall got a lot of news coverage at the time. So what that means and how that works. Changes for the way that using contractors in your business works, and things you may have to be aware of, and then a bit of a summary, some tips that we'd recommend to be compliant. As I'm going through, we've got a Q&A feature in Zoom. Do feel free to drop questions. I might have some time at the end for questions, but I also don't mind answering questions along the way. It can often help add some color to what I'm talking about. So anytime you think of a question, just drop it in the chat and I'll try and keep an eye on them and answer them as we go. So let's kick off by talking a little bit about what are these laws? What are the Closing the Loopholes laws? They are changes to the Fair Work Act, which is an Australian legislation, the main piece of legislation that defines employer and employee rights. And the Closing the Loopholes Act introduced a series of pretty big changes to that core act in an effort, as the name suggests, to minimize gaps that existed in employment laws, which people were using or exploiting for unfair practices. For political and other reasons, the law didn't all go through at once. So there was a part one that went through in December 2023, and then part two went through in February 2024. And much of the changes started rolling out from mid 2024 and some into 2025. And again, the reason we're talking about this, the reason we're doing a webinar on it, is because it had a pretty big impact on the way that employers and employees engage with each other. So just to begin with the top level overview of what were the big changes before we zoom in a bit of detail. In part one, we had the criminalisation of wage theft. And there's been widespread reports of businesses deliberately underpaying employees' wages, not paying overtime, not paying super. If you are found to have done that, there is now a criminal penalty, and that's quite significant because often in business, you might be liable for issues for negligence or other facts. Your business may be able to be fined, but you as an individual running the business or as a director, may not personally face penalties because the business is often, particularly if it's a company, seen as separate to you as an individual. But really, this law is looking beyond those distinctions and actually making directors who are engaging in deliberate wage theft practices potentially criminally liable, and certainly subject to pretty hefty fines of up to nearly $8 million for these practices. Now, there is a little bit of leniency for small businesses. It was mentioned in the reading speeches and the way the law was framed that it's understood, of course, that mistakes can happen from time to time. People might not get paid enough, not on purpose due to administrative errors or otherwise. And for small businesses, there is a sort of voluntary compliance code, which you can Google, and I would encourage people to have a look at. If you follow that code when you discover instances of underpayment, then you are immune from the criminal issues. You may well and likely will still have to repay the underpaid amounts, but you are immune from the more serious penalties. So it is really trying to target people that are engaging in schemes to purposely underpay staff, but it is still something that is widespread practice. There's been studies done, particularly in hospitality, where people are being paid cash in hand or being paid in ways where it's not compliant with various award requirements, and this law was really designed to crack down on that and has come into force on 1 January 2025. So definitely something to be ever more cognizant of in the way that you're paying your staff and making sure that they're getting paid what they're entitled to. There's an amendment to the small business redundancy exemption and insolvency. So employers that become a small business while they're downsizing might be required to pay their employees redundancy. There was a loophole before where if you were a big business and became a small business, your redundancy requirements were made lighter. So they've closed that loophole. Same job, same pay. This is a new piece of law specifically for labor hire workers, people that are not employing people but using labor hire agencies to onboard staff. Those labor hire workers can demand the same pay rate as regular employees. There's small business exceptions. There's a few other exceptions to that, but this is probably largely affects the construction industry, but also other industries that work with sort of temp workers. Accessing family and domestic violence leave. There's stronger protections for employees who have been subject to family and domestic violence from getting discriminated against for taking leave due to those kinds of issues. Again, if people are requesting that sort of leave in your business, treat this with care and make sure you're complying with the laws around that. And there's a criminalisation of industrial manslaughter. So if a death is caused by an employer being reckless and someone sort of dies on the job, then again, there can be criminal penalties for the employer who, recklessly may have caused this. And again, that may be more likely to happen in something like a construction context, but can happen really in any industry as well. And so this is where a bit more emphasis on work health and safety laws can help reduce the risk of something going wrong there. So that was part one. And then in part two, there were more changes, many of which we'll be talking about in this session. Casual conversion changes. For those of you engaging casual employees, there's some changes around when they can request to be converted to a full-time or permanent employee. It's been the case for some time that you can't necessarily indefinitely employ someone on a casual basis, but give them consistent regular work and deny them the right to be permanent. And so there's been some clarification around how that works. We have the right to disconnect. We'll be going to in a bit more detail, but employees now have an explicit right to refuse contract from their employers outside the usual working hours. Changes to the employee and contractor test. This is, for those aware of this issue, been a very fuzzy area of law for a long time, where people would not want to bring on an employee, so they would use contractors instead. But technically, under the law, that contractor may over time gain employee-like rights. So there's been an attempt in these laws to clarify how that works in a bit more detail and clarify who's an employee and who's a contractor. I must say it's not still 100% clear, but there's been some new laws around that. Gig economy workers, for those of you working with running businesses that are sort of platform businesses, with sort of contractors doing gigs, sort of Uber style platforms. More laws have come into place to provide some minimum standards for the gig workers. The actual standards, the law passed came into effect in mid-2024, but the actual standards have not yet been released. They're expected in the next few months. So anyone running a business like that, we won't cover it in too much detail today, but should be aware that your platforms will need to comply with these laws if you have gig workers on it. Unfair terms and contractor agreements. So independent contractors in any industry below a high income threshold, which we'll talk about in a little bit, can now say, if you give them a contractor agreement, they can now say, hey, this contract contains unfair terms. I don't want to agree to it, and potentially raise a dispute over those terms. And again, for those of you using template contractor agreements, this could raise an issue if they haven't been reviewed recently. And finally, in general, the regulator, Fair Work, has been given increased powers to issue bigger financial penalties, really to crack down on people exploiting loopholes in the workplace. So we'll go into some of these in detail, but you get a flavor for what they're trying to do here: plug a whole lot of holes and gaps where there's been issues in the workforce, and really try and make the consequences more serious for people engaging in workplace conduct that may breach the Fair Work Act. And so, as a more general or meta point, I think for any employer, if you've sort of not been thinking too much about your workplace compliance, and you're not really across the details of it, and you were hoping that you could, it's unlikely anyone's going to investigate me, etc. Now's a good time to really get on top of things, because these laws really signal that Fair Work is going to have more power and be a little more harsh in their treatment of employers for failures to comply with workplace laws. So it's a good time to commence that sort of cleanup process for your small business. So let's now start talking specifics. Casual employment changes. What's changed to the way casual employment works? Well, a few things. First of all, there's a new definition of casual employment. Then there's been changes to that casual conversion process and a few other changes. So I'll just go through each of them, starting with what is casual employment. So if you want to offer someone employment who is but not a permanent position, a casual position where they work on roster or otherwise, it must be truly casual employment. If someone's a casual employee, typically under an award, they'll get paid a little more per hour, but they're not going to get the same leave or sick leave benefits as a permanent employee, or the same level of rights. So for a job to be considered casual, or an employment to be considered casual, the definition is still what it was before. Any type of employment where there's the absence of a firm advance commitment to continuing an indefinite work. So the job description or the type of job has this ad hoc nature to it. But previously, the test only looked at the job description that they were employed for. Now, explicitly, the law says we've got to actually look at how the parties behave after the employment has started. So someone could begin as a casual, working on an ad hoc basis. But if over time, 3, 6, 9 months in, their work starts to become more consistent, more regular, more reliable, then the law will say, well, this person isn't really a casual anymore, or may not be a casual anymore. And so that definition has sort of changed. And so it's something to be aware of. And there's, what the law is trying to encourage employers to do is consider converting people on a casual employment basis to a more permanent basis. and also establish a process for periodically checking if that status might have changed. And so there was some changes in laws that already allowed or actually required employers to check every 6 or 12 months as to whether someone was still casual. Not that many people were complying with this law, and it was a bit of a high burden. So the way it works now is if you have a casual employee, they have the right to elect to convert to permanent employment by giving a letter or an email, a written notification to the employer saying, you know, I believe I'm no longer casual. I no longer have the absence of a firm advance commitment of work. You've been giving me regular shifts, and I'm, expected. And it's the vibe of this job now is that there's going to be ongoing work. So I'm no longer a casual in nature, and I've been here for at least 6 months. Or if you're a small business with under 15 employees, the threshold's a bit longer. It's 12 months. So they say I've been here for 14 months. I'm no longer casual. I want you to make me permanent. The employees have the right to request that. Now, the employers don't have to accept, but they do have to reply within 21 days. And they can only refuse to make them permanent on the grounds of, A, what you've said isn't true. You're actually still a casual in nature. So that test that we set out is still met. There's the absence of a firm commitment of future work, or there's fair and reasonable operational grounds, i.e., operationally, we can't support you being permanent. It would totally change the way the business works. It's going to have a pretty substantial operational impact if we had to make you a permanent employee. So you can refuse as an employer. It's not like you 100% have to take this person on as a permanent staff member, but you've got to provide a good reason. And again, this can be challenged and taken to Fair Work if there's not a good reason. So it is something to monitor. You also have to provide them with a notification of their casual employment information statement, which whenever a casual employee starts, you're meant to give them an information statement saying you're a casual, here are your rights, which is a template that you can get off the Fair Work website. And under the new laws, you have to re-provide it to them every 6 months or every 12 months if you're one of the small businesses. So again, you can't, the idea is many employees may not be aware that they have this right, and you have an obligation to inform them of their rights on an ongoing regular basis if they're a casual, to remind them that they have this right to request permanent conversion. So again, for anyone out there with casual employees, this is an important thing to be aware of. They may be casual for now, but they do have this right to make a request. And the longer they stay with you, the stronger that request may be. And you do have to, by law, consider the request, reply to it, and have a pretty good reason if you're going to deny it. So definitely worth keeping in mind. So just to give an example, to add a bit of color, we have Dan here, who's a casual employee. He works every Friday and Saturday night at Motley Cafe on a regular basis. His hours and days don't change, and the cafe has less than 15 employees, so it's one of those smaller businesses. Over a 12-month period, he misses 4 shifts due to illness. He also takes a couple of weeks off during university exams. Now, even despite taking a little bit of time off and having time off for university exams and missing some shifts due to illness, very likely he still is going to meet this definition of a regular pattern of hours. He's been working the same days, Friday and Saturday, the same hours for over 12 months. And so he now at the 12-month mark can send a request to Motley Cafe and say, "Hi, Motley Cafe, I've been a casual here for more than 12 months, working a regular pattern of hours. I believe I'm no longer a casual. I would like to convert to a permanent staff member." And if he makes that request, now he doesn't have to make that request. If he's perfectly happy as a casual, he may not make that request, and that's fine. But if he makes that request, the cafe has 21 days to action that request or refuse on reasonable grounds, i.e., sorry, Dan, if we did this, it would significantly impact our operations. and then provide reasons in writing to Dan. So then we have the third bullet. Of course, it was only 12 months because it's a small business. If the Motley Cafe had more than 15 employees, Dan could make this request at 6 months. So hopefully that adds a bit of color to it. I can see a couple of questions have come through. If a, sorry, I think my camera might not be working properly. If a casual would like to move to permanent, I assume that leave entitlements start when they commence permanent employment rather than from the start of casual employment. Yes, that is true in the case of annual leave and sick leave. In the case of long service leave, I would have to double check that, but my understanding is I think that would actually begin from the date of the start of their casual employment. But certainly for the other forms of leave, the more standard forms of leave, that's gonna begin when they become a permanent employee. So yeah, that's the answer to that question. We have our CEIS available on our equivalent of a staff intranet. The employees can access it anytime. Is that sufficient, or do we need to send it out again to every staff member every 6 months? I'd say the answer to that is it's unclear, but my view is Fair Work would probably not consider that sufficient, and they would require you to actually send out a reminder, even if it's just with a link to your staff intranet, to specifically contact them in a personal manner. I mean, it could be an automated notification. I think Employment Hero, which is a software that Sprintlaw uses, has an automated feature for this, and so that's how a lot of people are handling it, through an automated notification. But yeah, I think just having it available at all times, you could make the argument that it's there, they had a reason to access it, but the law is specific about requiring a notification. So yeah, my advice would be yes, be specific and actually send out a notification to every casual staff member. And again, at Sprintlaw we have casual staff and we're doing that. Natalie said, can an employee elect to remain casual despite them fitting the permanent criteria? Yes, and I mean they don't actually have to elect in the formal sense. They can just not request the conversion, and then they would remain as a casual. There have been some cases where people have been casual for a long time and then kind of made creative legal arguments that they should be a permanent staff member, and they haven't been paid leave and so on and so forth. And there's been cases before this law where that argument has been accepted. My view is it's unlikely though that those arguments will be very strong after these laws have now been passed, because the law has been quite specific that if you were a casual and you wanted to convert to permanent, it's sort of on you to make that request. As long as the employer has clearly notified you as to your right to do so, and if you choose not to, then you're still going to be a casual. And so again, in many workforces, to Natalie's question, casuals are quite happy as casuals. They're not raising this issue. You just, as an employer, have the obligation to provide them their statement of rights regularly, which is essentially a reminder that they can ask. And then if they want to ask, you got to consider it reasonably. But otherwise, they may just stay as a casual for a while. So hopefully that makes sense. So yes, I mentioned this already, but just to reiterate, the CEIS is the new important change, which I'm aware that many small businesses aren't complying with. The law's only been in force since August 2024. So you're kind of coming up to the 12-month anniversary of people that might have started after that date. But if you're an under 15-person business, so you should make sure that you got your employees, you've got their start dates, and you're sending out that CEIS reminder to them. If you are larger than 15 employees, you should have already provided it. If you haven't, I would suggest providing it as soon as possible, and then make sure you've got your reminders to provide it on every well, you've got to do 6 months after they begin, and then it's every 12 months thereafter if you've got more than 15 employees. So again, I would suggest businesses just sort of automate these reminders, and whenever you onboard a casual employee, if you can find a way to just either have calendar reminders or some other system for making sure you don't miss these dates of re-providing their information statements. A couple of other changes, fixed term contracts. People may or may not have been aware, but before it was unclear and potentially not possible to have a fixed term employee that was also casual. Now that is allowed explicitly, and there's some laws around that, except for some exceptions under certain academic teaching awards. And finally, and this is important, if you as an employer are found to have made false statements to a permanent employee to persuade them to be casual, or dismissed permanent employees to sort of make them casual, there can be fines and penalties for doing so. So you've got to be careful in the way you communicate around this. And again, I think having a re-provision of that information statement and just following the law in that respect is very clear. But you can't be telling casual employees, "Oh, you have no right to be a permanent employee. You're casual because I said so." Those sorts of things. If there's evidence of those statements, there can be fines and penalties. So just be careful in the way that you communicate around this stuff. And of course, if in doubt, always best to check with a lawyer if you get questions about this and you're not sure what to say. So that's the main changes on the casual stuff. Now moving into this right to disconnect. This is a new right that was introduced under the Closing the Loopholes laws. It got a lot of media coverage. And in some instances, I think the media coverage was overblown as to how significant this right is. But there is now this right to disconnect. So we'll cover what is it, how does it work, and how are disputes handled if they're raised under this new right to disconnect. So the right to disconnect is a new right that every employee has, and they have the right to have no contact with their employer or workplace, including clients or colleagues outside of their usual work hours, without being penalized. This includes the right to refuse to monitor, read, or respond to contact via phone calls, email, text, etc. So the third bullet here is quite important because some of the media coverage suggested that as an employer, you can't even send an email or forward an email to your employee outside work hours. That's not quite how the law works. Employers can make contact, but they can't make it a job requirement that the employee has to respond. The employee can respond if they decide to, but it can't be part of the performance assessment, the role requirements that they are required to respond outside the work hours. So again, if your employee likes to check their emails at 11 p.m. and reply to things, that's up to them, but it can't be a requirement of their job, if that makes sense. Now, there's also exceptions because in certain jobs, it might just be the case that it's a really important part of the job that for emergencies, for example, someone's available outside their normal scheduled work hours. And so again, the law specifically is only gives employees this right where the contact is unreasonable. And it doesn't leave that term completely undefined. It gives a bunch of examples. So if it's urgent, there's some kind of emergency, will be considered in determining whether it's unreasonable, how the contact was made. Did you spam their phone a million times, or did you just send them a quick text message? Did you have an on-call allowance? So someone's getting paid or getting some benefit for being available for interruptions on weekends or out of hours. If that's the case, then it would be reasonable to contact because they're being sort of paid for that on-call allowance. How senior is the role? If it is a very senior role, it might be considered reasonable for an executive to be contacted on a weekend for an important work matter as compared to, a junior employee. And what's the employee's personal circumstances? If the employer knows they have, family or caring responsibilities outside work hours, that's another factor. So that gives you a bit of a flavor for what we're talking about. There is this right, but it is really trying to not stop all contact, but stop unreasonable or unnecessary contact where, the employers are sort of harassing the employees or trying to get them to do more work than they're paid for, rather than, those reasonable cases where, you might need to check something because it's important and maybe it only requires a second of that person's time. Um, these are all factors that go into whether something is unreasonable. And beyond that as well, if an employee thinks that their right to disconnect has been breached, they can't go straight to Fair Work as well with a complaint. There is an obligation for them to try and resolve the dispute at a workplace level. And maybe they can make a request to their employer. I have felt that this is breaching my right to disconnect. Can we organize my job in a different way? And if the employer is cooperative in that process, it's unlikely to get escalated to Fair Work, or if it is escalated to Fair Work, it's unlikely to be enforced. So again, the way the law is drafted, it's envisaging an ongoing pattern of an employer breaching that right to disconnect, or like serious breaches of the right to disconnect before we're going to see orders from Fair Work. This is an important right for employees and one to respect, but also I think it's not designed to be massively disrupted to how businesses work. But it will be somewhat disruptive if you don't have procedures in place for being aware of this right. We've had a question come through. Does the right to disconnect include sick days, e.g. request the employee to check an internal system to call the first two clients to cancel reschedule appointments when they are sick? Also requires employees to carry a laptop home daily for this purpose, even though work is only on site. That's a difficult question. It doesn't specifically talk about sick days anywhere in the law. So what we would have to do is apply the reasonableness test. And so probably the answer to your question is quite dependent on more detail around what the business does, how it works, how many employees are there, other options that are reasonable than requiring this person to do this stuff on sick days? What's that particular employee's personal situation? So I don't think there's a black and white answer to that question. I think if it's one that's pertinent, it's probably worth getting some specific legal advice on. But probably what a lawyer would say to a question like that is, it's a little risky because you are, asking, and it's not just about the right to disconnect. There's also work health and safety laws, and if you're asking someone to do something while they're sick, that creates a risk for the business to say you've exacerbated their sickness. So if there's ways to design the system where that doesn't need to happen, it would certainly reduce your risk of employer liability. Of course, if it's not possible, then if you can design it in a way that's really minimal, and it's only required if the employee is not incapacitated level of sick, of course, et cetera, then you could potentially have a policy there that might be okay, but it'd be safer to design the system, I would say, without knowing all of the specific details where that isn't the case. So again, that gives you a little bit of a flavor in terms of how you can consider some of the specific scenarios. It is a bit specific, it is a bit case by case, but you probably want to be risk averse where you can in designing your workplace policies. So that's the right to disconnect. Moving now to the changes to the contractor and employee test. And again, this is a hot topic for many people that are using contractors in their business. It's known by a lot of people that are contracting staff that there's always this risk when you contract someone. They can, similar to the casuals, request that they be converted to an employee or claim that they are subject to what's called a sham contract, where really you should be employing them, but you didn't want to pay all the tax and give them all the benefits, so you just made them a contractor. So it's always been a little grey. They've attempted to clarify the test in these new laws in a bit more detail. So we'll talk about the new test and some other changes around how the contractor and employee thing works. So there's a new definition that we are now looking at if we're determining when you're contracting somebody for your business. Are they actually a contractor, or are they an employee disguised as a contractor? So the new language that's used in the law is now that the law is going to look at the real substance, practical reality, and true nature of the relationship to determine whether somebody is a contractor or employee. Now, you might be thinking that elegantly worded sentence is quite unhelpful, and still we don't really know what the practical reality means, the true nature means, and the real substance means. And I think that is a fair critique of this new test, in my view. But the reason that they've chosen this language is because there were some recent High Court decisions that happened just before this law passed, where the court basically implied in some of their decisions, in one view, they implied that if the contract itself was called a contractor agreement and the contractor had signed it, then they were just a contractor. And not quite that simple, but that's sort of what they implied. And so, the position had started to be that, people were just making more people contractors and saying, well, if you've signed the contract and agreed to be one, you can't later claim you're an employee. So this wording, we're going to look at the real substance, practical reality, and true nature of the relationship. It's saying, doesn't matter if you make them sign a contractor agreement, we're actually going to look at how they're treated. And if they are in nature an employee, they will be considered an employee by law. So that's why we have this wording. And again, it's intended to counteract the position from a couple of years ago that was emerging to be, oh, it's just all about the document, if that makes sense. So how does this work? Well, similar to that casual test, the test is determined not only by what happened on day one of the relationship, but how did the relationship evolve? Did someone start out as a true contractor, but sort of evolved and sort of became an employee at some point? And it might be that you have contractors who start to begin to work with you regularly, and they start to use your uniform, your email addresses. They start to work alongside your team. At some point, they may begin as a contractor but turn into an employee. And if so, you as the business, what you're meant to do is convert them from a contractor to an employee. If you want to keep working with them in the same fashion, begin paying them their superannuation requirements. If they're permanent, begin giving them their leave entitlements, and sort of evolve it from that contractor relationship. And if you don't do that, you can be liable for potentially unpaid super, unpaid leave requirements, and potentially breaches of employment laws because you kind of had an employee that you never gave their employee rights to. So it is definitely something that you want to start monitoring. Now, the law did introduce an opt-out provision, which allows certain contractors to say, I don't even want to be an employee. I want to stay a contractor. But it's quite limited. It's only for high-income contractors who are earning over 130K Australian per annum, or if it's on a quarterly basis or a half-yearly basis, a pro-rata version of that rate. So for most contractors, even if they don't want to be an employee, they don't necessarily have the right to not become one if they work in a particular fashion. Now, in practice, we have many clients who are using contractors that are kind of in the gray area, and the contractor doesn't really want to be an employee, so they just don't raise the issue. And so in practical terms, the issue doesn't come up. But that doesn't mean there's no legal breach there, because under these laws, there may still actually be a legal breach there, even if the contractor's not saying anything. They might change their mind and be able to make a valid claim against the employer later on to say, hey, no, actually, I have been denied my employee rights, and I want you to pay my super, etc., because I've been working for you. So it is, as you are probably picking up from this explanation, it's quite important with your contractors to make sure that they are truly contractors. I don't have on the slide all the different factors that are considered, but you can go onto the Fair Work website, and they've got some good pages and a couple of tools that you can use. I'll ask you some questions about the type of engagement that you have, so as to help you work out if a specific role is at risk of being a deemed employee, even though you're calling them a contractor. And it's things like I mentioned earlier, is this person using their own tools and equipment, or are they using stuff that you provide? If it's a physical job, is it literally their own tools, or is it your tools? Or if it's a digital job, is it your laptop or their laptop, your email address or their email address? Are they getting paid on an hourly rate, kind of like an employee, or are they getting paid for a particular result to deliver something? Is there work requirements consistent and on a specific days of the week for a long period of time, or is it more akin to a service or supply arrangement where it's not about when they work, it's about what they deliver. These are the factors that are considered, and the more it's results oriented, the more they use their own tools and equipment, etc., the more it looks like a contractor, and the more it's the other way around. It becomes indistinguishable from an employee. So these are the sorts of things you want to be thinking about when you're setting up your contractor operations and onboarding contractors to avoid the risk of them being deemed an employee. Samantha's asked us to check, was it 180K per annum or 130? It's 180K. And again, if you just Google high income threshold fair work, contractor high income threshold fair work, you can see on their website. That number may get updated every year, but currently it's 183, 100 is the specific number. Yes, very important to pay more attention again to your contractors to make sure they're not misclassified. Employers also have a narrower defense. Before, it actually may have been a defense to say, we just didn't really know. No one drew our attention to it, and it was a bit of a grey area, etc. It's a bit more strict now. Employers can only defend themselves from the penalties associated with this sham contracting if they can show objectively, we objectively thought that they were, and we were being objectively reasonable, we objectively thought that they were not contractors because we had all these reasonable grounds to think so. And again, if it is a grey area and you keep documentation and you've designed a system to make it clear as to why this person's being classed as a contractor, even if it's found that they are a deemed employee, you may not face penalties if you can show that you were reasonable in your belief. And so again, it's important to think about this in a bit more detail. The other aspect which I touched on earlier is in contractor agreements themselves, if you're using contractors, you now have to make sure that the terms of the contractor arrangement are not too one-sided for you as the company contracting them. Previously, it was considered to be a private arrangement between an individual and a company. We do have some unfair contracts laws, but for many contractor agreements, they may not have applied because contractor agreements would be seen to be sort of negotiated on an individual basis. Now, under the new laws, if you have a contractor agreement that is too one-sided and too harsh on the contractor, requires them to personally cover any loss of any issues that they cause, and requires them to do tons of unpaid rectification work, etc. Things like that, may be struck out for being unfair. They can raise a dispute over unfair terms and potentially hold you liable for including unfair terms. So for those of you out there using contractor agreement templates that you might have downloaded online, you got to be careful because those templates might, if you're using them, be breaching the laws. And certainly if you're using templates that were downloaded before these closing the loopholes laws came out, many of them would be in breach because your typical company-friendly contractor agreement that lawyers would have given you a few years ago would have been very balanced in the favor of the company. And certainly at Sprintlaw, we've changed the way that we draft these agreements since this law passed. So definitely worth having your contractor agreement templates checked to make sure that you don't have contractors engaged on unfair terms. Just saw a question come through. Do you need workers' compensation insurance for contractors? That's an interesting question. I've kind of mentioned it here. There's actually a different employee contractor test for superannuation and for workplace compensation as opposed to under fair work. So this issue does get complicated. In general, for contractors, the idea is they have their own workers' compensation insurance. But it is possible that you've got someone who's a contractor in the workplace sense, i.e. they handle their own PG and whatever it is, and they're not an employee with employee rights, and the tax sense rather, but in a workers' compensation sense, they're actually considered an employee because the test under workplace laws is its own test. So In general, the answer to that question is no, with that qualification that if they're really quite grey, you might want to check with your with WorkCover and ask them whether you need insurance for a particular person who might be in that grey area. So hopefully that provides a bit of clarity on that question. And finally, I mentioned this earlier, but we've got for those using those running digital platforms with contractors or gig workers on them, there's going to be some new standards for the way they're treated and protections for them, which again are not out yet, but coming out in the second half of this year. So if you're running one of those digital platform businesses, definitely pay attention to this new regime. So that's a lot of the detail I wanted to cover. Just to kind of recap on the kind of top tips now, practically what should you do with all this information about all these laws that have changed? I think 4 key takeaways. First one is work health and safety procedures. We talked on the sort of covering slides that there's these potentially criminal penalties for industrial manslaughter, but also things like the right to disconnect and other sort of changes around the family and domestic violence leave requirements are really implying that businesses should have better procedures for handling and caring about the workplace health of their employees. So if you don't have a work health and safety policy set up for your organization, it's a really good idea to put one together. It shows compliance, it shows a lack of negligence, it shows that you're thinking about this topic. And again, it's one thing to just have policy and procedures. You also want to operationalize them and make sure that you're having people either complete questionnaires or training or drawing their attention to the workplace health and safety policies and making sure that managers are aware of them. And again, there's great templates out there, the stuff lawyers can draft for you, but really every business should have one, whether you're running a construction business or even just a virtual business. There's still work health and safety risks, and you just want to make sure you're not being negligent and informing employees of the risks and having procedures for handling those situations. So work health and safety is one that will help manage a bunch of the new risks that these laws present for employers. We touched on the casual thing. Everyone should make sure that their casuals are getting those CIS notifications and getting them provided to regularly, and have a procedure for considering what you're going to do when somebody requests a casual conversion, because you have those 21 days to respond. And also make sure that managers of casuals are aware of these laws and not misleading staff or misrepresenting their rights to become permanent employees, because again, there are some penalties for the misleading information around how the casual conversion works. So at the work health and safety of the casuals, the right to disconnect, again, an explicit policy is one of the better things you can do. At minimum, you should at least have some processes around this, but many of our clients are putting together right to disconnect policies or inserting it into their workplace health and safety policy packs. But having something that helps managers and staff understand when and how they can contact employees, and explicit procedures for when it's okay to contact other staff members outside work hours and when it's not, and also to inform employees of their rights. It may be as simple as a manager saying, hey, I might email you outside of hours, but to be clear, there's no obligation for you to respond unless it's, in XYZ situation. Even having that initial conversation, recording that and writing somewhere, can reduce this risk, because again, there's not that many cases yet of how it will be enforced, but one suspects that there'll be many cases where a manager was communicating outside work hours and the employee thought they had to respond, and the employer or the manager never made it clear that they didn't necessarily need to respond until they came into work the next day. So you want to set those expectations and again have policies, procedures, and notify your team around this right, what it means, when it's okay and when it's not okay. The answers to those questions will be somewhat specific to your business, so there's not like a template that you just download and implement and you say, oh, we're all good. But certainly having a basic policy and then making sure everyone across the organization is cognizant of that is going to really help reduce the risks around the right to disconnect. And then finally, with your contractors, a really good idea to do a general review of your contractor agreements. If they haven't been looked at in the last year, I would get them looked at. If you're using an online template, I would be very wary and again, get them looked at. And not only get the agreements in order, but also make sure that your contractors are contractors. You're reviewing your list of contractors regularly to make sure that the way that you have them contracted is not at risk of them being able to claim that they're deemed employees around the way they're paid and the tools and those sorts of things. So those are some sort of practical matters to focus on. That is the content for today's webinar. If people have any other questions, I'm happy to stick around for a couple of minutes and see if they come through and answer them. Otherwise, as I said, do feel free to book in a chat with our team if you've got any specific questions flowing from this presentation. And I hope you found it informative and useful. We'll be doing another one of these next month on a different topic. If people have feedback or ideas of what they'd like to hear as well, would love to hear that from any of you. Otherwise, it's been fun and all the best.